Hi, my name is Lauren Fields. I lead the domestic litigation team here at Roth Davies LLC. In this video, I'm going to talk specifically about the division of assets and debts. There are several types of assets that the court is going to consider when divorcing parties. One of them is going to be premarital assets. A premarital asset is fairly self-explanatory. It is an asset that one of the parties had before the marriage. The value of a premarital asset is typically set aside to the spouse who came into the marriage with it, without the need to divide any equity with the spouse. However, if that premarital asset accrued over the course of the marriage, then that can be something that's subject to division. A common example of this would be a party who owns a house prior to the marriage that their spouse moves into them with. Say the parties lived there for about 10 years before filing for divorce. What your attorney would need to do is get the amount of equity in the house today versus the equity that the spouse had in the house 10 years ago when the parties did get married. If there's $300,000 worth of equity now, but at the time of the marriage there was only $100,000 of equity that accrued in the house, the parties would need to split that $200,000 that accrued during the course of the marriage. That would be considered marital property. Marital property is anything that the parties accrued together during the course of the marriage. Typically, the courts will divide this marital property equally. However, the statute does not require the court to divide it equally. The statute requires what is fair, just, and equitable regarding your assets, so it does not necessarily mean 50-50. However, absent extreme circumstances, the court typically does consider equal split of marital assets. The court can also take into consideration property that was acquired during inheritance. Inheritance is typically set aside to the spouse who inherited the property. There are certain situations, though, where inheritance can be subject to division and then it can become marital property. This is typically where a party has commingled their inheritance, such that the court is unable to discern what is actually inherited property versus marital property. This would look like putting your inherited amount in a joint bank account that you pay all of your expenses with your spouse in, then continuing to withdraw and deposit in that account. At that point, the court would be unable to trace where the inheritance went in versus where the marital funds went. The court would just consider that in most cases commingled marital funds and divide the remainder of the account equally by the parties. If a party is concerned about keeping his or her inheritance as separate property, my advice would be to keep that property in a separate account that is only devoted to the inheritance and make no withdrawals or deposits on that account. The court does have jurisdiction, however, to deem all property owned by the parties regardless of acquisition date or the method of acquisition as marital property and divide it equally. You may want to hire an attorney that understands the processes of dividing assets and debts and understanding the nuances of inheritance and premarital property. If you have any questions about this, please feel free to give me a call at 913-451-9500.